Hello, YouTube. I'm Vince White. I'm an employment attorney and making a whole bunch of videos today. Trying to stock up on videos and get these questions answered. This question is fairly old. It is 3 weeks old. It is a question from YouTube user Karma H, and getting you an answer today. I know I'm late. I'm sorry. I apologize. Yesterday my blood pressure was 160 over 98. So if I just stroke out in the middle of this video, you know why. All right. This video was posted by YouTube user Karma H. As I mentioned, it was posted on our July 20th of 2022 video entitled Last Chance Agreements. And Karma H asked, I recently came out of a settlement where in the back and forth, my employer claimed that I was an unreliable worker, a no-show, and that I had broken a non-compete. However, none of this was ever told to me, nor does any of this appear on my employee record, and I have proof in exchanges that these things were never issues. They only come up a year after they forced me out, and I filed a complaint regarding harassment and retaliation. Interesting timing. My attorney didn't feel the need to continue forward and pushed for a settlement when my former employer proposed it. Because my industry is pretty small and everyone knows each other, and because the same staffing agencies work with different clients, how can I be sure that the excuses and reasons they tried to use before won't be used against me in the future? Since they started claiming the issues were ones I had before my complaint, I feel like they're damaging to my reputation. But I waived any right to legal action for anything that happened while I was employed with them previously. Okay. Then I asked, did your settlement agreement include a neutral reference and mutual non-disparagement provisions? And Karma H replied, it did not. Just a release of claims. I told my attorney about my concerns regarding future employment, but I was simply told they can't deny me work or retaliate because I filed a claim. But it never stopped my employer from doing it before. Okay, so good news, bad news. Start with the bad news. No, start with the good news. Good news is your employer, your attorney, who I'm not really sure is an employment attorney, given some of the things that went on here, but your attorney is correct in that if your employer tries to ruin your good name in the industry, I would want you to look at a potential retaliation claim. So that's the good news. You have leverage. If this becomes an issue, you may be able to bring a new claim to fix that issue, maybe collect some money. And so you've got plays, you've got options, you've got tactical choices that you can make, and that's great. Here's the bad news. The concept of settling an employment case without, at the very least, a neutral reference for the employee from the employer is wild to me. That's like an industry baseline. I would argue that's a really good way to find out if you actually have an employment attorney. If you have a settlement agreement and there's not at least a neutral reference protection in there for you, well, I don't think you have an employment attorney. You've got an attorney moonlighting on an employment case. Maybe she or he doesn't know all that much about in terms of the field of law, right? That's just why. And I would argue the first thing you're going to fight for in any of these cases is the neutral reference and mutual non-disparagement. And mutual non-disparagement is much more difficult to obtain because the employers get nervous. Oh, what if somebody in my employ, badmouths this person? I'm going to be on the hook for all this money. And to that, I would argue, well, sure, but that's kind of how neutral references work too, right? It's actually not that much larger of a duty, employer. You need to be policing your people and make sure they're not speaking poorly about this person. But employers and their defense attorneys always look at a neutral reference as something that's easier to comply with than mutual non-disparagement. So often, while they will fight tooth and nail to the death to not put in a mutual non-disparagement clause in a settlement agreement, they will often, just as a matter of course, say, oh yeah, neutral reference. And what a neutral reference is, what it means is they only give the dates of your employment and nothing else. And many people watching this video will immediately say, oh, that sounds terrible. That would not be good. No, not the case. It's actually industry standard in many, many industries these days, because employers are afraid of various claims cropping up from giving bad references. So it's not rare, it's not surprising, and future employers will just say, oh, that's a neutral reference. They've confirmed employment dates. We see that all the time, so it's normal. It's not concerning. So the answer here is, I wish you had a better settlement agreement. I'm frustrated that your settlement agreement doesn't have more protections for you, but you do have options. You have a way to hold your employer's feet to the fire if they're trying to harm you. I would urge you to network really well in your industry. As you say, it's a small industry, and hopefully you have friends and allies who will tell you, oh, your old employer said X, Y, and Z about you, and it was not good. And then you can talk to an employment attorney, maybe an actual employment attorney this time. I kid. I'm sure they were amazing. And you can look at trying to square that away with a new retaliation claim if you have to. And I hope you don't have to. I hope you don't ever have to deal with these people again. I hope you can wash your hands of this crappy employer and be free and be happy and move on with your career. But I'm just saying you have options if you must. If they really want that fight a second time, well, I don't think you're going to be on the losing end of it, is my thoughts. Like and subscribe helps me to help more people just like you. Take care.